Thank you very much. Please be seated. We'll go on the record in the matter of State of Utah versus Martin McNeil. He is present with his counsel. The state's attorneys are present. We are outside the presence of the jury. Counsel, would you like to speak to the issue we dealt with at the bench? Go ahead, whoever's first.
After reviewing this, I don't think the statute addresses our exact situation specifically, nor does it deal necessarily with the issue of admissibility, but I think it does address it by way of analogy through the discovery process, which is if it's in a case of prescription fraud or Medicare fraud or Medicaid fraud or something like that, it is discoverable and the state is then authorized to send that to defense counsel. I think any other context under 601 is inadmissible to share that information, and certainly making it an exhibit and publishing it would be sharing that information in the state's mind. I'm uncomfortable with it coming in as an exhibit.
Could I just ask this question as I think about the context of the case? There will be testimony, or has been, there will be testimony that Michelle McNeil was a drug-naive person. I don't know what the database material shows. I suspect that it will show that she is not that, or she has had medications prescribed to her in the recent past. And if that's the case, clearly it would go to the heart of a claim or defense, and I'm wondering if the due process clause would, that as applied, that this limitation on access as applied would violate the due process clause, since that would be Brady material, essentially.
I believe the substances were from 2002, so the relevance is, in the state's opinion, marginal. We aren't objecting to counsel asking Mr. Mickelson about it, and if it refreshes his recollection in any way, I'm fine with that. I think they have the right to present their defense, and we will argue that this is not really relevant for a number of reasons our toxicologist will address. But in terms of making it an exhibit, that's where I have my most concern, Your Honor.
Is there could you make a proffer of what the toxicologist will say about who constitutes a drug-naive person?
I'd probably have to leave that up to Mr. Perkins.
I can make a rudimentary one, Your Honor. I think they'll testify that someone who has built up, that when someone takes a drug routinely, certain types of drugs, particularly opiates, the receptors in their nervous system adjust with certain chemicals that transmit the signal that the opiates are blocking. And when someone adjusts, or excuse me, when someone's body adjusts to a routine dosage of a drug like an opiate, that adjustment makes them tolerant to it and makes the effect less pronounced on them. However, if someone has not been taking the drug routinely over a period of time, they're no longer tolerant. Their body readjusts back to the normal status. And so in this sense, drugs that were prescribed in 02 or 03 and not taken regularly up until April of 2007, there really wouldn't be a drug tolerance there. And if she were not taking those drugs regularly, she would still be a drug-naive patient despite the fact that she'd been prescribed those drugs earlier in her lifetime. Similar to when a heroin addict goes into jail for 6 to 9 months and comes out, they no longer have the same tolerance and are at higher risk of overdosing.
All right, thank you.
Can I address one other issue?
Yeah, go ahead.
A couple other concerns I have, and as a prosecutor, I have charged a number of controlled substance violations based on a Doppler report that proved to be erroneous, and these people actually had prescriptions for some of the things they were charged for. And so I don't know that the Doppler report is the best evidence anyway. Certainly, Mr. Mickelson can testify about it, but it's the Doppel database is routinely mistaken on some things, and so those are some of my concerns.
I appreciate that. Thank you. Go ahead. Could I see it?
Yeah.
Yeah.
We're going to get a clean.
Okay.
That's the report as it was provided to us, Your Honor.
What is Mr. Mickelson's responsibility?
He's a nurse practitioner.
And he can't, so he can prescribe?
Yes.
Who will lay foundation for this?
It's my understanding we have a stipulation on foundation, and the question is admissibility for the statutory reasons that the state has addressed.
I don't object to that being the Doppel report for her. I think that's the truth.
Is your concern that Mr. Mickelson won't remember these prescriptions, and so
Well, that's part of it. He didn't remember them, and so we have shown him that. But we want this report in for a number of reasons. And we think that it is relevant both to indicate that Michelle isn't exactly drug naive, and also to indicate that back in 2003 that she was prescribed Lortab and Percocet together within approximately the same time frame that she was also prescribed Valium as well. That in 2006 she also was prescribed hydrocodone. Back in 2002 she was prescribed hydrocodone. And then in August of 2006 she was also prescribed Ambien. And so there will be some testimony. There'll be some testimony in this case, presumptively, from Alexis that her mother hated to take medication. And we think that this is some evidence to show that that's not the case.
do you have any, will you be calling an expert witness to testify about the issue of tolerance?
We have an expert who has been designated that if we call him, he will testify about tolerance.
What will he say about a controlled substance prescription given in 2006 for hydrocodone? Would that render a person no longer drug naive in April of 2007?
I think that he will say that's a tough question to answer, that determining how somebody's body will respond to a medication is something that is very subjective, and something that you can't simply tell by ascertaining whether or not they've ever taken a medication before. And so it's, as I understand his testimony, that it'll be that there are a lot of factors.
Is prior use between 5 and 1 year earlier one of those factors?
I believe that that's one of the factors to consider, yes.
Even that old?
I don't have a specific recollection to say exactly what he would say on that point. My recollection is that he will say that there are a lot of factors that must be taken into consideration, which does include prior use as well as other subjective factors for each person, their age, their gender. Prior use is one.
Mm-hmm. So in summary, your position on relevance is that it goes to the issue of whether or not Michelle McNeil was drug naive, and also to the issue of whether or not hydrocodone and diazepam should be prescribed together.
And Percocet.
And Percocet together. Is there any real issue about that?
Yes, I think that the prosecution's theory includes in part that my client, Mr. McNeil, looked at the PDR and came up with some theory of medications that he wanted Dr. Thompson to prescribe, and designed a potent cocktail that they think may have caused death.
I understood the state's witnesses to say, yes, as a matter of routine, we do prescribe these drugs together. That's not an issue. Yes, they can be dangerous if taken all at once, but we do prescribe them together. Have I misunderstood that?
I believe that that's what the witnesses that have testified thus far have said.
Am I going to hear something different from someone else?
The toxicologist, Dr. Dawson, describes the circumstances a bit differently, and describes it as a potent cocktail of drugs.
Okay.
And so I think this is critical to our defense to show that a good portion of what is called a potent cocktail of drugs has been prescribed to Michelle in the past, that she wasn't naive in the sense of taking medications because she had.
And that's using the term drug naive a little differently, and that's a third area of relevance, that she herself knew how to take these medications safely.
That's where I was going, yes.
Okay. Used not in the terms of a tolerance issue, but her own personal knowledge. Okay.
That assumes she took the drugs that were prescribed to her as well, right?
Okay.
This case is full of circumstantial inferences that both sides are seeking. And, Your Honor, as you mentioned, there was due process where the statute doesn't prohibit this report from being admitted. It deals with dissemination. In this case, it has been disseminated to the defense.
Yeah, and in my view, appropriately so, even though it doesn't relate to a defendant in a criminal case, which is the access permitted by statute. I think clearly under the Constitution it's exculpatory and would need to be disclosed under the Due Process Clause. I think the state has appropriately disclosed it.
I do too. And to now say that it was appropriately disclosed, but you can't admit it, I think, would
Yeah.
be a due process violation. And I hope that we've established sufficient relevance that Your Honor will allow us to.
Read as the statute reads, it would suggest that the only time the state prosecutor could disclose information from the database in a criminal case would be when the information is about a criminal defendant for the purpose of establishing a defense. And I think at least in the context of this case, the evidence is exculpatory when taken in context, and I think the state has appropriately disclosed it under the prosecutor's constitutional obligations. Do you wish to be heard any further?
The only other thing I want to add, Your Honor, is that I didn't understand the multi-purpose approach to this
Yeah.
disability. I thought it was to refresh Mr. Mickelson if his memory of it was different from what Doppel would have recorded. I didn't understand we were getting into this whole thing, and so I'm frankly not prepared to address that, and I would prefer to deal with the admissibility for everything she's been prescribed previously in a different way. When it comes to Mr. Mickelson, I think he's more than capable of testifying to what he did. In terms of the whole document coming in through him, I again would object to that.
So you do not have a stipulation on foundation then?
Well, I'm in a tough spot because I told Mr. Spencer I agree this is what Doppel has produced. I thought it was for the limited purpose of refreshing Mr. Mickelson of what he had done. And so if it's to bring in the other things, I would object to those at this point.
Let me ask this. Do you need this document today to examine Mr. Mickelson, either of you? Do you need it today?
I need it just to refresh his memory. I mean, it doesn't necessarily need to be admitted today, but I would like to talk to him about the document.
My concern then is, if all you're going to do is say, does this refresh your recollection, he can read it, then take it from him, and he can testify from his memory. But if he says, no, it doesn't, then we're back to where we are right now. So, Mr. Peed, you said you're not ready. What more do you need?
I want to review, for example, Your Honor, we have records from, is it Shopko or Target? And I want to review because, again, my concern is that the database is just simply not kept up as responsibly as it should be. I want to review each of those future prescriptions against what other evidence we might have, just in
Does
terms
that go
of
to
accuracy.
Right, does that go to its weight, though, rather than its admissibility, and we would look at those other, you may demonstrate that it's wrong.
Sure, and similarly, I'd want to talk to someone about the limits and such that it entails.
In terms of data entry.
Correct.
No, and I don't want to make this a trial about the state's database.
Sure.
I think we need to think carefully about, we don't want this trial to turn into a mini trial about the state's controlled substance database. What I will do is reserve ruling on the admissibility of, can I just mark this? Is it Defense Exhibit D? I'll reserve ruling on Defense Exhibit D, allow you to use it today to refresh his recollection with the limitations we've talked about. I don't want him to take the document and begin to read off it. He can, orally, read it out loud. But he may look at it, read it, see if it refreshes his recollection. If it does, great. Take the document from him. He can testify from his own memory at that point. If it doesn't refresh his recollection, and I suspect that it may not, given the number of prescriptions he's probably issued, at that point, let's take a bench conference and we'll decide where to go from there. It may mean that Mr. Mickelson's testimony will have to continue tomorrow. when we have some more time to talk from that point forward. Let me provide this back to the defense. For the record, the defense has offered into evidence a report from the Department of Professional Licensing Controlled Substance Database. Access to information from the database is governed by statute, Title 58, Chapter 37F, Part 3. Under the statute, state prosecutors may receive information from the database so long as they are engaged in a specified duty of their employment in enforcing laws, regulating controlled substances, investigating insurance fraud, Medicaid fraud, or Medicare fraud, or providing information about a criminal defendant to defense counsel upon request during the discovery process for the purpose of establishing a defense in a criminal case. In the context of this case, the information from the database does not relate to a criminal defendant, but rather the alleged victim of a crime. It would be offered for the purposes stated by defense counsel. First, to demonstrate that certain medications at issue in this case are prescribed together. Second, that Michelle McNeil was not a drug-naive patient and may have had a tolerance to certain medications. And third, to show Michelle McNeil's own personal knowledge of how certain medications might be taken together and safely. Given the state's theory in the case, the information from the database does constitute exculpatory evidence, which, despite the narrow reading or the narrow language of the statute, I believe the state properly disclosed to defense counsel pursuant to its obligations under the Due Process Clause. Whether or not the report from the database itself is admissible, I'm reserving on, and you may examine Mr. Mickelson in the way I've indicated. Let's have the jury brought in.